Okay, good morning, everyone. Thank you for being here. Before we get started, I'm going to go over, first of all, introduce myself again. I'm Fatima Berkey. I'm a collection attorney with Condominium Law Group. This is probably my fourth or fifth Zoom Q&A, and glad to have you all here today with Ken. And to get started, I'm just going to remind everyone that we are here to provide general legal information. We are not here to give legal advice. Anything we say in this meeting, in this Q&A session, whether it's in the chat feature or verbally expressed here, is not to be taken as legal advice. In a couple of administrative matters, we wanted to let everyone know here that Senate Bill 5129 did pass. It has not yet been vetoed, so we do expect it will be moving forward. This is related to, this will be effective January 1st, 2026. The Wakaiowa sections pertaining to meetings, voting, etc., will be applied to all community associations. So please, you may want to consider looking over having your association attorney look over your governing documents to determine what, if anything, may conflict with the statute going into effect. Another point is that Senate Bill 5686 also will be going into effect, it looks like, on January 1st, 2026. That one is pertaining to the pre-foreclosure mediation for homeowners facing foreclosure. There's a mediation provision there that will very likely be going into effect. I want to correct something I said earlier. I meant to say Senate Bill 5129 did pass. That is definitely going into effect regarding the Wakaiowa sections for voting, meetings, etc. With regard to Senate Bill 5686, pre-foreclosure mediation, it has passed, but there is a pending veto, which it does not look like that will be happening, which means that this will be going into effect most likely January 1st, 2026. Ken, I think I got that right when I corrected myself. Is there anything you wanted to add to that?
One of them was signed by the governor already.
Right.
The other one is just sitting on his desk.
Right.
And my understanding is if he doesn't sign it, it still goes into effect.
Right.
But he has the chance to veto it if he wants to.
So there's a chance it may be vetoed. As of now, we expect it will not be. Again, this is for Senate Bill 5686 regarding the pre-foreclosure mediation process. Let's see, am I missing anything else? I don't think so. So we only had 4 questions today, which we are prepared to answer, and we will be going through those questions. Thank you for submitting them. As of the last meeting, we did have attendees had expressed interest in a primer on the due process requirement that affects certain notices that are required to owners. And we thought we'd kind of just go over that briefly today. Ken and I, questions arise, we will try to answer specifics. However, there's a few obvious notice, we call it notice and opportunity to be heard is sort of our language for that, even though that's not exactly what the statute says. Essentially, there are certain decisions that certain things that you cannot do without providing notice to an owner before you do it. So one obvious one I deal with often in collections are fines that are related to an owner's failure to follow the rules of the association. For example, parking violations, violations regarding trash removal or the appearance of their property, failure to maintain, etc. This is one that we see often. When we take in a new collection matter, we review the file. One of the things we look at are what fines have been assessed in the management ledger, and if those fines were properly assessed. And if they were not properly assessed, by giving notice, a warning notice, a due process notice to the owner in advance of actually assessing the fine, that is not collectible. So that's something to keep in mind. another, Ken and I sort of went through this together ahead of time, a few others that pop into mind that are clear indications where notice is required would be entering a unit not in an emergency for perhaps inspection purposes. We talked about fines. Towing a vehicle is not something that a homeowners association can do without giving notice to the owner in advance. Certainly eviction would be one that pops into mind. Let's see. Ken, did you have a couple others you wanted to throw in there? These are just the ones we initially talked about. Also assessing, we talked about insurance deductibles. When those are assessed to an owner's ledger, that needs to be, an owner needs to be notified in advance before that type of, that amount is added to their ledger balance.
Yeah, that one especially is going to be a big change when Ukiah takes effect,
Yes.
because there are many, many insurance deductible amendments which have been adopted by communities over the past 20, 30 years even, that clearly state that an owner has to pay for the deductible for damage they cause or damage in their unit. But Ukiah requires that you give notice and an opportunity to be heard before that assessment can be made. And so the question, I guess, is how do you give notice and opportunity to be heard? And the statute is really vague about it. It doesn't define what notice and opportunity to be heard means. The the shorthand for it that many managers and associations use is due process, under the theory that you need to give a fairness kind of opportunity to the owners. So some of the declarations that were written over the past 20, 30 years, especially by an attorney named Jim Strickerts, had included some really specific and onerous requirements for how you had to give notice, the number of days you had to provide, whether it had to be sent by certified mail, who sent it. Well, it might say the secretary has to send it. And then it would set up a procedure where you had to give, a minimum of 10 days notice, and you had to have a presentation by the association and then a presentation opportunity for the owner. It just was a lot of work. It was, sort of designed to copy a legal process. And that's not necessary unless it's in your documents. So we don't write that kind of a complex procedure into our documents. We recommend people remove that, because all that's really necessary is that you give advance notice and offer that an owner can request a hearing before the board or a committee of the board, so that they can explain themselves or they can contest the the fine or whatever it is the board wants to do before the board takes action. So we see a lot of fine schedules come through our office where it will say there is an automatic fine for some kinds of violations, because a lot of communities, they are so concerned about a particular kind of bad behavior that they will just write into their rules that if you do this thing, you're just going to be automatically fined. And I have to keep telling them that the statute prohibits them automatically fining. I'm not saying there's not a violation. You can find a violation the first time something happens, but you cannot send a fine. You could send a violation notice and give them the opportunity to be heard, and then assess a fine after the opportunity to be heard, but you can't assess the fine without the opportunity to be heard. And some people think that that means you must have a hearing. Well, the answer is, unless your governing documents require you to have a hearing, you just have to offer the hearing to the owner. And there are some of the governing documents that actually are very clear. They state that when you find a violation, you must schedule a hearing. And so we would normally say, just schedule the hearing at your next board meeting. And you would tell the owner that you've scheduled the hearing. And if they show up, you would have the hearing. And if they don't say that you must schedule a hearing, then you have to at least offer the hearing. And if the owner requests the hearing, then you have to have the hearing. We do have some clients that don't want to have the hearing. They do not want to confront the person that they think is in violation. And so they just won't ever assess the fine. They'll send the warning letters, they'll find the violation, they'll try and get some kind of cooperation from the owner, but they don't want to have a hearing, so they don't assess the fines. And that's okay. You don't have to have a hearing if you don't want to assess the fine.
But you can't assess the fine without offering a hearing. So it's just, the main point is that you as an association want to be familiar with the procedural requirements in your governing documents, your rules and regulations about how fines are assessed, and make sure you're following those to a T. Otherwise, those fines can't be assessed. And as Ken says, if you don't want to have a hearing, then we won't assess the fines, or you won't assess the fines. So that's a decision the board can make, certainly.
Right. And then we also get a lot of confusion about whether or not an association can assess a fine and offer an opportunity to appeal it, under the theory that the appeal opportunity is the same opportunity for a hearing. And the answer is the statute says that you have to have the opportunity before the fine is assessed. It's not ambiguous.
No.
And the court's going to rule in favor of the unit owner in something which is about the process, because they believe the process is fair to the owner only if you let them explain themselves first. And when we say opportunity to be heard, we're not saying the owner has to challenge the violation. They may agree that they had violated, but they may have an explanation, or they may be asking for sympathy from the board, or they may offer some way to solve a problem that would satisfy the board. So when we say that you have to give an opportunity to be heard, it's not just that they have an opportunity to contest the violation. It is that they have the right to come before the board and say anything they want. And so my advice typically when I'm asked how should a meeting be conducted for a hearing to provide the due process, it usually I suggest that the board member who's running that meeting thank them for coming in and say, you asked for this opportunity to be heard by the board. We're listening. And then you can shut up and let the owner talk. Because until the owner talks, you don't know whether they're there to contest the event, to contest the fine, to offer a solution, to apologize. You just don't really know. And you should give them the opportunity to speak first and say what they want to say. And then you can adjourn to make a decision about whether or not you assess the fine or enter the unit or do whatever it is that you were considering doing. You don't have to be in an argument when you do the hearings, because it doesn't have to be, in most cases, you proving a violation. Now, there are some exceptions to that, because some of these due process procedures, which were written by the other attorney or included in some governing documents, actually do say that the board has to present evidence of the violation. Now, I'd like you to have evidence of a violation. It should have already gone out to the owner. I like things like a photograph of a car parked illegally, or, if you're fining them for garbage cans left on the street, a photograph of the garbage cans left on the street is very helpful. So, unless there is a requirement in your written due process procedures that you prove and present evidence, then you don't have to do that. That's not what an opportunity to be heard means. Any other thoughts right now, Tima?
No, I think we covered that without, getting too specific. But generally speaking, that should be helpful to those of you who are interested in the due process
Yeah,
requirement.
you do not need a written process in order to comply with the statute. Okay. Because it's relatively simple to comply with the statute. You just have to make sure you give them a notice, which is as provided in your declaration or the statute, that the board wants to do something, assess a fine, or, make them do something, and whatever it is, and tell them that they have an opportunity to speak to the board about it before it happens. You can give them a timeline, 10 days or 14 days to respond. And you can assume if they don't respond in that time that they have waived the opportunity to be heard.
Exactly. And then from the collection, once that time has passed, so that would be considered a warning letter notice. And then once that timeline has expired, the 10-day, 14-day deadline, then you would follow up with an actual fine letter stating that the fine's been assessed. Typically is what we look for when we are reviewing a collection file and applying fines to the ledger. But again, it will depend on the specifics of your governing documents in that event. Should we get to the first question?
Well, unless there were questions
Yeah.
specifically about due process, and I haven't looked at them.
There were some follow-up questions
Okay.
about due process. So first is, should violation hearings be held during the public board meeting if the governing documents don't specify?
So I'm going to offer that it's a gray area, because if you look at the HOA Act and Ukiah on what topics you're allowed to do in an executive session, meaning not an open session, it's not clear to me that the violations are always covered. I think it's likely that the violation hearing could be done in a closed session, especially if the owner requested it. But it is not clear what the legislature intended. It is clear the legislature is trying very hard to prohibit closed meetings. If you're a condo association, you can still do closed meetings for the next 7 months or 6.5 months. But Ukiah has been amended so that all the meeting sections are going to apply to you January 1st of 2026. And so I think that there's some risk, and I would want to know what the hearing was about before I decided whether or not to adjourn into a executive session in order to discuss the violation. And like I say, I think that there's a good argument for most circumstances, but it really may depend on the particular circumstance. So if it was related to construction or, something Architectural Control Committee has done, it might be that it has to be done in an open session. If it's related to some kind of conduct that is, I don't know if it's the dogs barking or something. I can imagine there could be some things where the owners would want to have the matter kept private, and it would be reasonable to keep it private. But I don't think there's going to be a bright line rule.
All right. What about late payment fine for late HOA dues? Must due process be followed?
So there's a few things when it comes to late fees and interest applied. Again, typically that's where we look to your governing documents to see what's authorized in your governing documents. Some authorize late fees and additional collection related fees that are very general. Some only allow for interest. Some allow for both. So there's a few things we look at with regard to late fees and interest. But however, that is a different, we would look also at what is required in your governing documents before sending a file to collections and adding those late fees. So for example, if your governing documents require that the owner be notified that late fees are being applied, then you would need to give notice. But generally speaking, that is something that you would automatically apply to their ledger, and that is authorized directly by by your declaration, by your governing documents, or perhaps you may have a collection policy that further specifies exactly how late fees and interest are applied. We would look at if the late fee is being applied at the correct time. Sometimes we see management ledgers where the late fee has been applied on the wrong date. So then we have to go back and correct that. But generally speaking, that is not the same, it's not treated the same as a fine.
Okay, so I'll add to that, and I'm using as my example the Condominium Act language right now, which is 6434-304 subsection 1K. And the statute language specifically says in the first part of the sentence that the association can impose and collect reasonable charges, or excuse me, impose and collect charges for late payment of assessments pursuant to 6434-364. So the first part of the sentence is you can assess late fees. That does not require an opportunity to be heard, because then the sentence has the word and, comma, after notice and an opportunity to be heard by the board of directors, end comma, you can assess fines. They have to be reasonable fines. So late fees are not fines. They are late fees. They're different than fines. You do not have to have notice and an opportunity to be heard. But I have also seen some clients start to do other kinds of screwy fees, and they may be crossing the line into being fines, but a late fee is not.
Agreed. And I think what Ken's point regarding late fees is there's another level of scrutiny here, which is what is reasonable. So we also look at what may be in your governing documents, and obviously the statute allows for that. But then more specifically, there have been times that we have determined that the late fees assessed are not reasonable, that we're seeing. And so we may, in a situation like that, go back to the manager, the client, and say, we have reviewed your governing documents, we have reviewed your management ledgers, a $200 fine on a $100 assessment is not reasonable. Now, I'm not going to say there's a bright line rule there, but when it comes to collections and we're putting these amounts in an owner's ledger, we do have to look forward to what type of court scrutiny we may face down the road. And so we may either adjust the late fee amount in that situation, or in some cases remove it. In other cases, we may leave it in the ledger and advise the client that if it later comes under scrutiny, we recommend to waive it.
You have others on due process, Chelsea?
Sorry about that. What about expenses the association incur if the owners does not maintain limited common areas? In our case, the backyards, is that considered a fine?
So there's two possibilities. One is that you're fining them for failing to maintain. The other would be the association goes in and maintains it and incurs an expense. I think both of those would require a notice and an opportunity to be heard before they are assessed to the unit. But they are different, sort of like if there is an expense caused by misconduct of an owner, which the Condominium Act and Ukiah both allow to be assessed to an owner, it still requires notice and an opportunity to be heard before it can be assessed. And to follow up on something Tima said earlier regarding the insurance deductible, once Ukiah is effective for your community, you have to give notice and opportunity to be heard before the insurance deductible can be assessed to the unit.
All right. What about recurring fines? Do recurring fines need to give an opportunity to be heard? Is a letter stating you remain in violation and your fines continue the sentence kind of drops off there, but I think it means to say, is that enough?
So
So,
I would
yeah,
offer that safest is to provide the notice an opportunity to be heard every warning or every violation or every fine. But if you have clearly provided the notice an opportunity in at least the first notice, and you have a fine schedule that allows you to do weekly fines for continuing violations, I don't think you need to send out another notice every week. But you have to have really clear documentation about the first one. And if you're trying to get compliance, you will need to have some additional follow-ups. I'm amazed sometimes when I um, get a request from a client where they have been fining an owner for something for 6 months on a weekly basis, and they haven't talked to the owner or sent any communication to the owner for more than 6 months, but they want to assess a fine for 6 months worth of violations. And it starts to be difficult for me to find a way to argue that that would be reasonable if I ended up in court over it.
that's a good point. And that is something that we look at when we are doing our pre-foreclosure analysis, when we look at when we do our internal risk assessments, we look at, again, the reasonableness of not just late fees, interest, but also fines and how that's been communicated. Because the point of the notice isn't just so that you have the ability to put it in your ledger. The notice is also meant, as Ken said, to alert the owner that they need to correct this issue. And so there's two things involved here. Yes, fining them is the result of them not correcting the issue, but you'll want to make sure that the owner is at least getting the statutory notice requirement, is meeting the statutory notice requirement of what exactly it is they need to correct and when, and give them a deadline. So that we see often I will see a warning letter and a fine letter for each fine that is in an owner's ledger. So if there's 10 fines, there's 10 warning letters and 10 fine letters. That is not uncommon. It's not a bad practice. It's certainly a very good practice from an administrative standpoint and an enforcement standpoint. But as Ken said, we look at these things on the whole. And if it's clear that the warning letter went out, provided adequate notice and opportunity to be heard, and the fine letter that went out after that, it actually, states this fine, for example, will be recurring until this is corrected, we are unlikely to reject it.
All right, just so you guys know, there are 3 more questions directly related to this topic.
Okay.
If executive session is used for a violation hearing, what information is required to be announced prior to the executive session or included in the minutes, specifically unit number, account number, violation, etc.?
Well, it's not exactly clear. I would suggest that if there was a violation that you reference the unit number or lot number, and you would state that it was regarding a violation. I don't know that you need to put more detail about what the violation was if you're going to do it in executive session. But the statute also then would require that if you're going to take action, like you are going to assess the fine after the notice and opportunity to be heard, that you come back into the open meeting and have a motion recorded in the minutes to assess the fine to the lot and how much the fine is for. And that has to be voted on and recorded in the minutes in open session.
Related to the term reasonable, in your experience, has an HOA defined for itself what is reasonable or stated particular goals?
I haven't seen an HOA try to describe what is reasonable. I have seen HOAs explain for very specific instances how they determined what was reasonable. My best example is when a board adopted a fine for renting in violation of their governing documents. they set the fine equal to the amount of rent that the landlord was collecting. And they didn't tell me why they had this $2,000 fine per month. And I said, $2,000 seems unreasonable to me. But they came up and said, well, their method of determining the fine was to make it economically unviable for the owner. Basically, it would be neutral to the owner to have a fine equal to their rent, so that they felt that was reasonable. And that was an argument I could present in court and argue was reasonable without being laughed out of court. So I accepted that was okay. But I've also had clients that want to double their fine every time something occurs. And they started with $100 fine. So you went from 100 to 200 to 400 to 800 to 1,600. And once you start getting into some of this for, something like failing to flatten the cardboard box before you put it in the recycling bin, or having a Christmas decoration out longer than was allowed by your governing documents, then those kinds of large doubling fines start to look unreasonable to me. Having written the policy that way, saying you're going to double the fines every day, isn't necessarily unreasonable. It's the application of it after the fact that might become unreasonable. So you can have a fine schedule which is higher than what you actually fine following the notice and opportunity to be heard.
All right, at the notice of opportunity meeting, how many board members have to participate?
Well, I think that I would fall back on whether or not you're trying to essentially allow a committee to act on behalf of the board. And the committee requirements under the statutes, I'm going with Ukiah here, would be a minimum of 2 board members. I have another client I was working with last month where they had written theirs so that as long as a quorum of the board was present for the hearing, then the hearing was considered valid and the board members in attendance could act on behalf of the board. But if you're doing it with a committee, you need to have delegated the authority to that committee instead of the full board. You could have a hearing where the information is then brought to the full board later for a decision about whether to find a violation or to assess the fine. And we have, the statute seems to allow you to delegate the hearing process even to a manager or a non-board member, but not the decision-making process. So you could have the hearing conducted by a non-board member and then the information presented to the full board so the board could make a final decision.
Right, we did get one more on this topic. Do all fines have to be approved by the board?
That's the safest way to go. If the fine is part of a schedule, I think you could qualify that as a ministerial act, but it still would require approval by the board to have the fine assessed to an owner. So I think, yes, the board needs to authorize the fine.
Right, like generally speaking, in other words, the fine has to be something that's been approved by the board for specific things. And so I don't think what Ken means is that for each individual owner, the board doesn't need to approve each individual warning letter sent to each individual owner that is going to be assessed a fine. However, you do need to have board authority to assess the fine to begin with. I think that's what you mean, right, Ken?
Well, in part, it depends how much risk you're willing to take. If you have, we'll just call it a something which is like the automatic fine. You can find the violation because the event occurs. let's say you're not allowed to have dogs and someone has a dog. So you send them the letter and the dog's not taken away and the 10 days passes, there's no opportunity to be heard that requested. And so, the question is, well, can the manager or one board member assess the fine without having consulted with the rest of the board? And I'll offer the low risk option is the board makes the decision. The higher risk option, even if it's detailed in your documents, is for the manager to do it without consulting the board. So my preference would be the board makes the decisions. All right, well, shall we go with the questions that were presented in advance now? Chelsea?
It looks like one more came in. Can a board give the manager the ability to assess fines?
So I think we just answered that. I suppose they can, but Ken prefers that they don't. Am I stating things correctly, Ken?
No, I think that's correct.
They can, but Ken says no.
And it's going to depend on the type of violation, I think also.
And the amount, again, back to reasonableness. So none of these are going to be, I think what we're trying to do is give, as we said, guidelines, not legal advice. So we're providing guidelines. Hopefully, this gives you a sense of what's required. And when in doubt, when there's a question, err on the side of caution, and consult your association attorney.
Yes, and remember that compliance is your goal in most cases, not revenue.
Correct.
So if an owner challenges a fine but agrees to solve the problem you're fining them for, I'll say often we would just recommend that clients waive the fines.
Yes.
Especially if they're paying their dues otherwise.
Exactly.
We don't want to be pursuing a collections matter for $100 fine when the owner is otherwise now compliant and paying their dues.
Correct. So when we get a management ledger where owner is paying their assessments every month on time, but there's thousands of dollars of fines assessed, that is not a collection. From the collection attorney standpoint, that is not something that we typically would look at. We would look at that with a lot of scrutiny, and we would most likely recommend a different course of action. That we're not going to send a demand letter and record a lien for a ledger that is all fine. That's just not something that is enforceable. So think about reasonableness, think about proper notice, all of those things. And again, if you have questions, ask your association attorney. I think that's the best way to handle things when you're not sure. So our first question that was submitted in advance: when is it appropriate or legal for the association president to make decisions alone, including spending money, without board approval? So I get the first thing to say here is that the president, that there are basically two different types of things we're looking at here. We're looking at delegated acts. So if your governing documents specifically if in your governing documents there are specific acts that are to be performed by the president, for example, that is different from, for example, emergency provisions or delegated day-to-day tasks. So if the only board approved decisions can the president make anyway. So the president can't, to answer your question, the president can't act out of a delegated authority, whether that comes from the governing documents or whether that comes from board approved decisions that have made that allow the president to make specific, to perform specific acts. For example, the president can call a meeting if that's been delegated to the president. the treasurer can pay the electric bill if that's a specific task that has been assigned to the treasurer. So for example, spending money, that was a specific question there. Well, if the treasurer is authorized to do that, then they can. But the president can't make decisions alone without board approval under any circumstances. There are emergency provisions that should be that you should be aware of in that, for example, RCW 6490 502 sets out very specific emergency provisions where the board can act without prior in specific situations where there's an emergency, the board can act alone. I'm trying to think, what else did we discuss here, Ken? I think I covered the major points, but you may want to add some details.
Yeah, I think you've pretty much covered it. The idea is that boards are the decision-making body. No individual board member has the authority, as a general rule, to make a decision on anything. And you did say that some governing documents do specifically say the president can do some tasks, but it's usually limited to just calling a meeting in order for the board or the association to make a major decision. So anyway, second question here is, what happens when the president of a board resigns? Does the vice president become president automatically until the next election, or should the board vote to update new officers? Should we wait to fill the empty board seat until the next election, or can we appoint someone to fill that position now? So you've kind of got a mix of questions here. One is about replacing a board member that has left the board. The other is about the office of the presidency of the board becoming vacant. So if the office of the president becomes vacant, even if that person stayed on the board, the vice president could temporarily perform the duties of the president, because that is part of what the vice president does. They act when the president's not available. But that does not make the vice president the president. The vice president can become the president only when the board appoints them to be president. And the board might not appoint the vice president. They might instead appoint some different member of the board. If you're talking about an actual vacancy on the board, the statutes provide that the board can fill a vacancy. Depending on your government, sometimes that vacancy is until the next election. Sometimes that vacancy is filled until the end of the unexpired term. So if the term was 2 years and there's 18 months left on it, the person might actually be in the position the full 18 months. So the RCW 6490 410 is the Ukiah section, which addresses board positions and officer positions, and you can reference that if you need to. But it's basically the office of presidency is at the pleasure of the board, and you don't get to automatically fill it just because you're the vice president. Anything you want to add, Tima?
Sorry about that. Nope, I think you covered it. The third question we have here is the board organizational meeting considered an open meeting? If so, how is notice set up? Or do the new members agree on a time, assuming everything is virtual? So I'm going to back up by saying the HOA Act has an open meeting requirement currently. Starting January 1st of 2026, Ukiah for All will apply this open meeting requirement to all community associations. So from the standpoint of, if we're just specifically talking about an HOA right now, an open meeting is required for any type of meeting. So that would include an organizational meeting under 6438, 35, section 4, if you want to look at that. So again, if you have an open meeting requirement, the organizational meeting is also open. Looking ahead to what we are facing, it's best that all meetings be, it's best that all community associations begin to think about the open meeting requirement, since this will be something that everyone needs to comply with very soon. That being said, currently the Condo Act and the new act do not have an open meeting requirement. So in that case, you'd want to look at your governing documents, but it would be best practice to consider an organizational meeting as an open meeting. When it comes to notice requirements, you'll want to look at the provisions of your particular governing documents, governing statute. Sometimes but in any case, 14 days minimum, 50 days maximum is required under the HOA Act in terms of providing notice to the owners in advance of a meeting. And the statute also requires the time and place and topics to be discussed be included in the notice that's provided in advance, as well as authorizing virtual meetings. Those are permitted. So let's see. Did I miss anything there, Ken?
Well, the only thing I would add is that some governing documents, either bylaws or declarations, will specify that the organizational meeting is supposed to occur immediately following the annual meeting when the election has taken place. And so you're not going to have additional notice go out. The notice has already been provided in the declaration or bylaws. And so the organizational meeting should just take place immediately following. And all that really means is that the board members who've just been elected stick around at the end of the annual meeting, and they get to choose who's going to be president, secretary, and treasurer. They can change it at any time later at another regular meeting, but it does allow you to have a designated president, secretary, and treasurer immediately following the election.
Yes, good point, Ken. Thank you.
All right, so next question is, my HOA board recently had an impromptu unofficial meeting where the members were excluded. I'll assume they mean the owners rather than the board members. This was not an emergency or an executive session. There was no agenda published prior and no minutes published after. Was this legal? What recourse does the membership have to curb this activity? So I can't give legal advice, so I can't tell you if it was legal or not. I can tell you that the general rule is that all meetings have to be open, and both Ukiah and the HOA Act specify that you are supposed to call a regular meeting, have a motion to go into executive session stating what the purpose is. So it certainly, from the question, sounds like the board did not comply. And as to, what recourse does the membership have? Well, one recourse is that the membership can recall the board and have a new board put in place. This is something that's not an easy thing to happen, but it can happen. If you don't think your board members are doing what they're supposed to do, you can attempt to have a vote to remove them and replace them with a board that will comply. If they are doing something which is actually contrary to the requirements of the declaration or the statute, you can try informing them of that to see and ask for them to comply. May or may not work. You can hire a lawyer to send them a letter to ask them to comply. Theoretically, you can file a lawsuit against the association, maybe even against individual board members for their failure to comply, but that becomes an expensive process. And it also is not a particularly fast process. So, I don't know what the circumstances are. There's certainly the potential that there was a legitimate reason for an emergency meeting that was closed. I don't have the facts to be able to give an opinion on it. Anything you want to add, Tima?
Nope, I think you covered that pretty thoroughly, Ken.
Well, I should cover, though, that if it was a condominium association, not governed by Ukiah,
Sure.
and not having an open meeting requirement in their documents, then it's still okay for the next 6.5 months.
Yes, for a little while longer.
All right. So Chelsea, did you have more questions for us?
Yes, the first one we've got is, Can the HOA disable pool and clubhouse key cards if homeowners are behind in assessments beyond $1,000?
I think the answer is yes. It made, I'd want to look at the specific communities governing documents, but the statutes provide, at least Ukiah does, provides that you can restrict an owner's use of common elements that are not necessary for the owner to reside in their home. So that would mean if they're delinquent, that they can be denied access to the swimming pool. And the dollar amount would not actually be relevant. And there also could be circumstances, where you might not be able to do it. So for example, if a owner had a requirement to exercise for health reasons, then I might say you should use caution in trying to restrict use of the pool. Anything you want to add, Tima?
No, other than I would just reiterate that I think it's going to be very specific as to that particular owner, the particular amenity or that is being restricted. But generally speaking, I agree with what Ken's saying.
All right. Can you clarify the assessment of the insurance deductible to a unit owner? We advise unit owners that they need to have insurance to cover the deductible amount, but they can choose their own policy, individual deductible, etc. Will that need to change?
So the ability to assess the deductible to an owner has to be contained within your condominium declaration or your HOA declaration. You can't just adopt a rule. And then what you've described in terms of allowing each owner to choose their own policy and their own individual deductible all is consistent with both the insurance deductibles we write and everyone I have seen from another law firm. The difference that I was commenting on is that under Ukiah, before you can make that assessment, you must give notice and an opportunity to be heard. That is not written into most of the insurance deductible shifting amendments. And I'll say the past practice that we see all the time is that you just assess the cost onto the owner's ledger. There is no opportunity to be heard. And so what we're trying to do is get people to understand that if their governing documents allow the deductible to be assigned to an owner, then they can do it, but they must have an opportunity to be heard before the assessment takes place. Just the way a fine requires a notice before it is assessed.
Would the deductible be similar to the loss assessment insurance that is currently being asked for older condos?
I would say no, they're completely unrelated. A loss assessment coverage under an individual owner's policy is designed to cover repairs to common elements that the association is assessing to an owner, whereas the deductible is for repairs specifically to the unit. The unit owner is only insuring and paying for their unit.
All right. If a board is not complying in some material manner, is there a way for a judge to grant an immediate hearing?
Complying with what?
Well, I'll offer that when you say immediate, there are some court proceedings which theoretically allow you to walk into a courthouse and stand in front of a judge, what they would call ex parte usually, and get an immediate temporary order. I cannot imagine that a failure of the board to comply with some procedure is ever going to qualify for a circumstance where the court, a judge, would decide that due process requirements of the law should be ignored. So I think that the probable answer is no, you can't walk in and get an immediate order from a judge. You would have to sue the association, and you would have to give them an opportunity to respond to the lawsuit, and you could try and schedule a hearing in front of the judge for a preliminary injunction to force or restrain the board. In the real world, you'd be talking weeks for any of that to happen at a bare minimum, and you might be talking months for an actual judge to issue a ruling, even a temporary one.
All right, and that looks like that's all the questions from the chat.
Well, that's enough for today. Thank you, everyone, for attending.
I forgot
And,
to mention next week's session is canceled. That's right, right, Chelsea? Okay, so please take note of that. We are not conducting a Q&A next week.
Okay, but we'll see everyone on the 21st then.
Thank you so much.